I've just been terminated, asked by my company to leave. Can I sue them? Because I don't think it was fair. I was a good performer.
Remember that for employment, it is a contract between employer and employee. They do have a right to terminate you for any reason whatsoever.
They're just exercising a right that is been protected by the contract. Today we have Ivan Lee, partner at PD Legal, who will be sharing on the topic of employment law.
Don't inconvenience yourself by commencing an action where the outcome is not going to be what you want. Just seek legal advice.
Hello again and welcome to the show. Ivan, thank you very much for joining us and welcome to the show.
My pleasure as always. Thank you for having me.
Let's go straight into the topic. I've left my employer. I want to work somewhere else. Employer says no, I can't work in the same area. Some people refer to this as a restraint of trade.
Yes.
Or restrictive covenant.
Okay, so a restraint of trade, usually comprises of a few clauses, right? We have the non-solicitation clause, so you can't take any of my customers.
Okay.
We have the non-compete clause, which generally means you cannot work for any of my competitors.
These come under the umbrella of restraint of trade. Restraint because they confine on the restrain the employee from doing something.
That's correct.
But the way they are restrained, from what you described, is not just one. It's not just about working for a competitor, it's also about not taking former colleagues with me.
Yes.
Right? And that's the non-solicitation.
Correct.
That's of employees, but there's also non-solicitation of clients and customers as well. Would that be the same?
Yes, so they fall under the broad category of the non-solicitation clause.
There we go. Okay, so how often will the courts enforce this?
Well, so right now, the courts and parliament as well, they're moving towards, being stricter on this restraint of trade clauses. Basically, the concern here is that it is unfair or unreasonable for employees to be restrained from carrying out their business, right? They develop certain skills and expertise in the course of their work, especially in cases of non-compete, right? You're basically preventing this employee from carrying out his business and earning a livelihood.
And making a living.
Exactly. So the way the court sees it is that the starting point is these clauses are not enforceable.
That's a starting point. They almost presume that as the foundation.
Correct.
Okay.
So it becomes on the employer to justify why these clauses are necessary.
I see.
Yes, and actually in 2 cases last year, it showed that they are taking a much stricter approach to it, right? 2 cases actually involved Money Smart and Shopee. So I think quite familiar brands to us.
And everybody knows about these companies.
Yes,
right?
and it involved high-ranking professionals in those businesses attempting to join a competitor, right? And Shopee and Money Smart sought to restrain that by filing injunctions and taking up actions against these employees.
Basically, the employers, the companies sued the employee who left to say that you're not allowed to work for another similar company or competitor.
That's correct.
Right, okay.
And
how did that case
both cases, the court found that the non-compete clause was unreasonable.
Wow.
Right, so the key concern here is that there has to be a business interest that the company is trying to protect, right? And you have to articulate this well in your employment contract, and you'd be very specific, right? So in particular, in these 2 cases, what was found was that there's already a confidentiality clause, right? So your Money Smart and Shopee's main concern was that these high-ranking employees would use the confidential information and basically use it for the benefit of the competitor.
If we can maybe just not rewind, but maybe take a step back first. In an employment contract or any sort of a service agreement between an employer and an employee, it could even be a contractor as well, right? But in any of these engagement terms, there would be, of course, all sorts of clauses. And this is really to touch on the foundations first. What exists in a typical employment agreement, right? And I'm not going to go into much detail, but the point I'm trying to lead into is this. When a person works for a company, there's a set of terms. And these terms will govern the relationship. How much am I going to be paid? What is my job title, my job scope? What are things I have to do, but also what are things I cannot do? For example, I can't give away or misuse or abuse confidential information. And that's what you talked about, the confidentiality clause. It's a clause that says that as an employee or maybe even former employee in the future, if you ever leave, whatever you come across, or you encounter, and you either keep or you touch or you retain or you know about, you're not supposed to use it for any other purpose except for this company.
Yes.
Right? In simple terms, that's what it means. And what you're saying is, if the employment agreement mainly wants to protect that right, the confidentiality clause very often already does that.
Exactly.
Right? And the point is that if employers try to say that you're not allowed to work for another company because I worry and the fear and the danger is that you will then use this confidential information. That's not the correct way to do it, and they can't do it, right? Because
Correct.
there's already a clause that exists specifically
So,
for that.
Right now, the concern is really what are you trying to protect? And most companies are going to say, oh, I want to protect my confidential information, I want to protect my trade connections, my clients.
My trade secrets.
Exactly.
My list of clients, the way that I do things, my pricing, anything that's top secret.
Exactly, and these were the reasons that the employers, right, Shopee and MoneySmart used in their cases. And the court basically said, confidential clauses there, right? So confidential information, this employee can't divulge it. Your trade secrets and client connections are being protected by the non-solicitation clause. So what further value does this non-compete add other than to prevent this former employee from finding another job?
So that's we'll come back to that case in detail later on, but that's an example of how the courts are objective and they don't just blindly follow what's written in the contract.
That's correct.
Right? Meaning they will look beyond, not beyond the contract, but beyond what is written to see whether this makes sense. Right?
Yes, and I mean that's primarily because there is an understanding or recognition that there is inequality in bargaining power when you enter into this kind of employment contracts.
That's right.
You as a lay person, probably not legally trained, you are negotiating with your employer. Your employer has probably legal counsel,
So
external
what
lawyers.
impact and relevance is that, the unequal bargaining position?
Oh, so the court will basically put the companies to task. If you want to have all these clauses in which impedes your employees from finding alternative employment, you need to have a good reason for it.
You can't just say that, well, he understands English, he read it, he had a chance to say no.
No. So I think the courts have accepted that it's against public policy to impede free trade.
I see. Okay, so good. So that answers some questions. Then what about what we see very often about not just the fact that you're not allowed to do it, but where you're not allowed to do it. So we hear about many questions where my former employer is suing me or telling me that I can't work in the same industry, which you've talked about, but also not even in a certain geographical sort of catchment.
Yes. Right? So the first stage, if the employer manages to prove that there is a legitimate proprietary interest, a business interest that they need to protect, then the court will then look at whether this clause is reasonable or not. Right? So if you're going to have a clause that says, for example, an employee is restrained from working with a competitor in the same industry for the next 10 years, that is definitely going to be unreasonable. Right? But if you say restrained from working for a competitor for 3 months, right, that's going to be more reasonable. Right? So reasonableness is important. There are things like geographical location. Right?
Sure.
Are you saying that he can't work for any competitor worldwide?
Correct.
Are you saying competitor
Which is
in
quite
Singapore?
extreme. Which is quite extreme.
Yeah. Or are you saying in a 3-kilometer vicinity from your company, from
your former
from
employer?
From like your restaurant?
I see.
Or hair salon.
Which may make a bit of exactly. If it's a hair salon or any other sort of a retail B2C type of business setup, it might be reasonable and acceptable to have a more realistic catchment defined.
Yes, yes. You have to be specific. It can't be overly broad, and that's what the court looks at. Right? There used to be a tendency for employers to draft very wide restraint of trade clauses. Right? Sometimes what they do is they'll have this kind of cascading restrictions. Right? So you're restrained from working for a competitor for 12 months. But if the court finds that that's unreasonable, we reduce it to 9 months. So on and so forth.
Is that right?
That's what that's what they used to do, but the courts have now clamped down on that.
I see. So even that's not allowed.
Yeah, because basically what that does is encourage businesses to keep their restraint of trade clauses wide, and then have basically lower it down until it is acceptable to the courts.
Okay. So that's the general position and that's the general situation. But now let's look at it from two competing sides. From the employer's point of view, how can they then protect their proprietary interest or their fear, or to mitigate their fear or risk of an employee actually going to whether steal business from former customers or to use confidential information?
In today's climate, the effectiveness of non-compete clauses are eroding. Right? The court's taking a stricter view to it. MOM is also coming up with a set of guidelines.
Is that right?
Yes, because I think they have recognized that employment clauses tend to be a bit unreasonable and exploitative. So now they want to come up with a set of guidelines so that businesses can see what is reasonable in terms of restraint of trade clauses. Right? So given that, I would think that businesses should now focus on strengthening their confidentiality and non-solicitation clauses. Right? To me, a non-compete clause tends to be unreasonable because again, you're depriving someone of having a livelihood.
And if you really have to say non-solicitation, because again, I not digress, but one other related point is many employees will say, I didn't solicit the former customer. It is an open fact and well-known fact that I have now moved on, and they have now come to me, and I haven't solicited, I haven't invited or gone to encourage them to come to me. Would that count then as non-solicitation?
Okay, I see that quite often, and I think it would depend on how the clause is drafted, right? I think what you're talking about is sort of like you're taking more of a passive role, right? Yes. One of your long-time customers knows that you're leaving, and he only wants you to service it.
That's right.
So I think in those cases, it really depends on the employment contract. But even if the employment contract says that you can't take on this kind of clients, right, where you're taking a passive role, I would think the court will find that unreasonable, right? Because not only are you depriving your former employee from taking on business, you're also depriving your former customer from going with the person he wants, or the business he wants.
So still standing on the side of the employer, if there ever is a need and a real risk that cannot be covered by the confidentiality clause, and there needs to be some sort of restraint of trade or non-compete or non-solicitation clause, then the word that keeps coming up is it has to be reasonable. Yes. It has to be sensible. It has to be fair. It cannot be too one-sided or oppressive towards the employee.
Correct.
Meaning, and again, there's no fixed rule.
It's very fact-specific.
Yes. So it could be 3 months. 3 months after you leave, I think that's fair for you and I, because that will cover a bit of an overlap immediately after you go. And I, as a business, will then do whatever I can to retain my customers to ensure that they don't leave. Maybe that's what they should do.
I mean, there are a lot of other factors, right? How senior or how important was this former employee to the business?
Correct.
How much confidential information does he have in his possession?
Yes. Or if the fact is, I know that I'm in a very niche area, that the geographic location, whether it's within a country or within a region of the world, is very important, then to limit that, again, sensibly and realistically as well.
Yes, so it always has to have a close connection to the actual work performed by the employee. Right? I mean, there are a lot of other factors as well. I mean, fact specific again, right? Yes. So you can have a case where you came up with a new invention, right? You have an IPO about a certain product, or let's say you don't have an IPO about a certain product, but this company perhaps sent you for courses, paid for your master's degree, assigned the R&D team to help you create this product, and now you're leaving the company. I would say in such circumstances, it is more reasonable to have a restraint or trade clause because there is going to be this concern where you are going to go to a competitor and use all the information and knowledge that you've acquired because of the company. Very fact specific, but I think in today's age, I think for most people, non-compete clauses they will not be enforceable.
I'm going to come back to that later because that's one of the main, I think that's the main conclusion that we're going to have to come to. Not as a simple statement whether they will always be upheld or not, but I think people want to know where things stand generally. Okay, but now from the employee's perspective, if I or a person wants to leave, should there be this overwhelming fear that I'm going to get in trouble, or because otherwise people will never be allowed to consider moving on to another role or another company?
Exactly. I think for the public at large, I don't think they have to be concerned about non-compete clauses. Right? If you're talking about high-ranking employee in a certain company, maybe that fear or concern might be more founded. But in most cases, unless your restraint or trade clause is very specific, very close connected to the work that you're doing, I don't see that.
So, not putting you on the spot, but again, let's really generalize and simplify. Hairdressers again. Let's just say hairdressers or interior designers or any sort of thing that is a bit more artisanal, creative, and unique to the person doing it. Right? There's a skill involved, right? Or maybe even sales, or maybe let's just say a car salesman. Let's just say any one of these fairly common types of roles. For the person leaving, and there's no one-size-fits-all answer, but generally, would you say that there wouldn't be any reason to uphold a non-compete clause for that type of person?
I would say in most cases.
In most situations.
Yeah, I would say so, because I mean, in those kind of industries, I think what you are most concerned about is losing your customers, right? Or well, losing your confidential information, things like pricing data, maybe suppliers and all that. But those are covered under a confidentiality clause most of the time.
Can you prove that a person has used confidential information? And also, even if you can, damages.
Yes.
What is the loss to the company? So this is jumping a few steps ahead to say, even if it was upheld by the court, what really is the amount of compensation that the company is going to deserve? You need to prove that because of you using this information, and let's just say in a situation where it's not so obvious, I haven't taken 5 of the customers away. You know, it's just the feeling or the fear that you have now remembered what the pricing model was and that you used it. But how has that made your former employer lose money, right?
Yeah, I mean, again, right, the court's only going to compensate you for what you've actually lost.
Correct.
Right? So just because the employee takes away confidential information, you have to prove that it has some impact to your business.
That's right. So using the hairdresser's analogy, say they have moved from one end of the country to the other, so very little geographical sort of overlap, right? And let's just say there's also no overlap in terms of time. Let's say 6 to 8 months later he does it. But they still insist on suing, and let's say there is a basis to uphold it. The former employer has a loan, would then still have to prove that by doing this,
I've lost business.
Which is also another stretch, because how easy is that going to be, which is not?
Yeah, it's going to be difficult to prove. I mean, you can look at the number of customers that actually went to the other salon, but
that's okay. This is going into a little bit of legal terminology, but there's also this causation aspect as well. You need to prove that the loss, the drop in your income and revenue was as a result of this person doing it, right?
Yep.
So I think just to leave it there first before we move on to the next topic, the point is that it's not one size fits all. Neither of us are saying that in every situation the court will blanket, always say no to the employer trying to sue, right?
Yep.
We are just saying that it's something that the court and the people in the policy positions are mindful of, right? To try to be fair to both sides, right?
Yep.
And
there is a shift to a more pro-employee stance.
And even if there wasn't a shift, it's not so linear. It's not so automatic that just because big employer wants to bully or sue small employee, they will win because the contract says so. And certainly, even if the contract is watertight, they still have to prove damage was caused by you leaving and doing this, right? And all of this is my very long-winded way of saying, and maybe whenever an employee receives a demand letter from a former employer, maybe don't be too overwhelmed by it.
Yes.
Don't give it no attention, but understand that it's not the end of the world.
Easiest way, just consult a lawyer. Yeah.
I couldn't agree more.
Yeah.
When in doubt, at least speak to one.
Yeah.
Engaging one is something else, but at least speak to one to understand.
Exactly.
Okay,
Totally
we'll
agree.
move on to the next topic, which is still employment related, wrongful dismissal. Right? So we'll start this from the perspective of an employee. Very often, we get inquiries, questions saying, I've just been terminated, asked by my company to leave. Can I sue them? This is the employee speaking. Can I sue them? Because I don't think it was fair. Right? I think I was and very often the scenario is something like this. I was a good performer, maybe even top performer. Right? And there was no reason in my mind, this is the employee speaking, that I could see for them terminating me. And therefore, the only conclusion is that it must be unfair because it was not in keeping with, my performance. What I just described, would that constitute unfair dismissal? And even if it doesn't, or if it does, what actually does unfair dismissal mean?
Okay, so in the scenario you just gave, it depends on whether you're terminated with your notice pay or without your notice pay. That's usually where the crux of the issue is, right? You got to remember that for employment, it is a contract between employer and employee.
Correct.
They do have right to terminate you for any reason whatsoever.
Or,
right? So this is
or
usually
maybe even no reason, would you say that? As
No,
long
for
as
no reason at all.
because they're just exercising a right that has been protected by the contract.
Exactly. I mean, I would say it's similar to the position of the employer, right? I mean, you as an employee, you can resign at any time for any reason whatsoever, right? Just because you want to take a break or maybe you're unhappy with your employer, you can.
And let's extend that a little bit. Just because the company has been good to you doesn't mean that you don't have the right to leave, because that's flipping it around.
Exactly.
Right? Because employees very often feel that just because I've been working well means that you have no reason, realistically or sensibly, to want to ask me to go.
Exactly. Right. So usually where wrongful dismissal comes in, and I think, we'll talk a bit about this later.
Sure.
The Employment Claims Tribunal, right? I think there was, they published some data a few years ago saying that I think somewhere around 70% of wrongful dismissal cases that were filed were actually unfounded.
Oh.
Right? So it's not actually a case of wrongful dismissal. And I think this is where emotions usually come into play.
Yeah.
When the employee is terminated, they usually feel that it's a wrong done to them.
Emotions, and if I can just insert this point here, education. I think the part of what this is meant to do is to not tell people that there's no hope, but to at least just set the context and set the understanding.
Yes, you need to know what your rights are and what the company's rights are.
Correct.
Right. So usually wrongful dismissal, it's a matter worth considering if the company refuses to pay your notice pay. Right. So most contracts you have a notice period of 1 month or 2 months. Right. They're supposed to allow. If an employee resigns, it allows the company to find a replacement. Right. And if you are terminated, it allows you to find a job within that notice period. Right? So wrongful dismissal usually comes about when, let's say, an employer fires an employee on the spot. It says, you're leaving, I'm not going to pay you your 2 months notice period.
When the employer not only says, I'm not going to pay you what your contract says I need to, but either I have on purpose or accidentally given you a reason that is actually unfounded.
Yeah.
I say that, you know what, I'm terminating you because you're not a good performer, you're the worst performer. When you are not only decent, above average, maybe you are the top performer, and maybe on that basis, would you say that
well, I would say
be a
yes,
claim?
yes, that
Potentially?
Okay, so when we talk about claims, we need to look at what the potential end result is, right? So if I terminate you and say you're the worst employee the company has ever had, even though you're actually the top performer, right? But I say, okay, but I'm still going to pay you a notice pay. Your 2 months notice, I will pay it to you. The reasons for your termination might be wrongful, but what are you actually getting at the end? Because if in cases of wrongful dismissal, what you are actually being awarded at the end of the case is what you would have received if the termination was done properly.
Can I also again expand on that? Is it possible, or is it one of the claims that an employee would bring to also ask for reinstatement to the position?
Okay, so
I know it doesn't make sense because the relationship is already so fractured. Neither of us are on good terms right now, but I either ask for what you would pay me under my notice, which is the minimum, or I might ask for my role to be offered back to me.
Yes.
Right?
So, it is actually in the Employment Act that if you start a suit in the Employment Claims Tribunal, one of the remedies that they can give you is reinstatement.
That's right. That's why I asked.
So that is a possibility, but I don't have the data on this. But I would think the tribunal would be very wary of ordering reinstatement because it doesn't make sense, right?
Because it's a matter of time. Technically, very, very technically speaking, you could be reinstated and then 2 months later be terminated according to the terms of the contract.
Exactly. Practically, how did you preserve that relationship between the employer and the employee when this employer wants just
on that note, and I don't think we're jumping around too much, but then is it possible, is it open for the employee to consider also saying, loss of opportunity, or now that you terminated me, I'm in a very niche role, it will take me 6 months before I find another job. Is that a legitimate claim?
It would be very hard to argue that, right? Because everything is in contract, right? The employer has a right to terminate you, right? So even if your termination was unlawful, was wrongful, the court is going to look at what you actually deserved if everything was done properly. And that's usually confined to your notice period. Right, so if you think you're in a very niche role, you can negotiate for a longer notice period at the start of the contract.
So before we leave it from the employee's perspective, what we hope people will at least understand is this, that the employer actually doesn't need to give you any reasons beyond just saying that I'm giving you the notice, or I'm giving you whatever your contract says I need to give you in order to terminate this relationship.
Yes, the company has a right to terminate you as much as you have a right to resign.
Because it's just a contractual term.
Yes.
Right? And again, just to dispel any other misconceptions or myth, is it a requirement for the employer to give the reasons for for termination.
No. You can just rely on your contractual right to terminate an employee.
Yeah. And you can talk about many other things about your performance, and you can give, feedback and criticism or critique or information for the employee to take on as a matter of closure, but that is not quite the same as saying those are the reasons why I terminated you.
Yes.
Right?
I mean, at the end of the day, I think one of the first things I look for is, has notice been paid? Right? Are you being paid your 2 months notice pay?
Yeah.
Because if you are, even if you do feel that the dismissal was wrongful, and even if it was wrongful, you aren't. There's very little the court can do for you in terms of.
And when you say notice pay, what you're really meaning is was there compliance to the terms of the employment contract when it talks about how any termination should be done? In terms of giving you ample notice, which is time, or if I want to shorten that time, I pay you the notice period.
That's correct.
Right?
Yeah.
That's what you're talking about.
Yes.
Okay, so now let's look at it from the employer's perspective. Should they remember not to give reasons, or are there any tips or insights you would share to help employers avoid putting themselves in a very precarious position of giving the wrong impression that they're giving any reasons for the...
Well, okay, so I would say you don't have to give reasons, but pay the notice pay. Right? If you don't want to pay the notice pay, you need to have very good reasons.
Let them serve it out. No, if you either pay notice to shorten the period, that means that you let the person leave quicker, but they still need to be rewarded for the period that they're supposed to have been working.
Yeah, so notice pay, I mean usually two scenarios, right? The first is, notice period is 2 months, so you work for another 2 months and then you leave.
That's the usual case.
Yeah, I'll pay you your 2 months. The other way is salary in lieu of notice, which is your notice period is for 2 months, but you leave now, I'll pay you your 2 months. You don't have to come in and work. Garden leave.
Yes, but either way, those 2 months of your notice period, that means the advance warning between the day that you're informed and the day that you leave, that's covered.
Yes.
And you get paid either because you're working there, or you get paid in advance and in place of, in lieu of.
Yes. Right. So that has to be done. If you don't do that, you need to have very good reasons why. Right? You need to have your evidence lined up on why there was misconduct. Right? Usually this will be things like maybe dishonesty, right? Sexual harassment.
Do you think maybe sometimes the overlap or the misunderstanding of the legal topic is this, that there has been an incident, that it could be insubordination, it could be dishonesty, it could be misconduct, and it's an open investigation, and as a result of that, they are terminated, right? So they're terminated with notice as a result of that, but they are unhappy with the investigations and findings, and therefore they connect it as because they are related, but they could also be standalone.
Yeah. So I think it depends on what the employer is saying for the termination, right? Are they saying I'm terminating you because of X incident?
Yeah.
Or are they just saying I want to end our relationship?
Would you say
here?
it's actually not just technically, it's perfectly acceptable to have a full investigations, or maybe not investigations, a full review of a person's performance and find that this person is actually not doing great, and then draw a line and say, okay, done, full stop. But on a separate note, we're going to give you notice anyway.
Yeah.
Because we are entitled to under the contract.
Yeah, I would think that is the best way to do it, right? Because, I mean, your investigations could reveal that this employee was dishonest. You could find a justifiable reason for the termination.
But you don't have to connect that reason.
You don't have to.
Right?
The only reason why you would do that and terminate it because of an employee's fault is because you don't want to pay notice.
Which is a nice way to kind of bring this to a close. And that is why maybe from the employee's perspective, they know my incident has something to do with you changing your impression of me. Because that's a reasonable inference and conclusion. It might even be a fact. But that's not quite the same as saying that was the reason for the employer asking you to go. The employer is just simply exercising its right under the contract.
Yes.
In the same way, and I know it's not exactly the same, but in a similar way, if the landlord also wants to just say, I'm choosing to exercise my right and not extend your lease or renew your lease, even though you've been a great tenant to me.
Yeah.
Right? Paying on time and not giving me trouble. I'm just simply exercising my right.
Yeah, exactly.
So that's something that might not be very easy to digest and accept,
Yeah,
Right?
especially when emotions are hot. Yeah.
Correct, but it's a matter of the contractual terms just having effect.
Yes.
Right? Okay, so just to wrap up, would there be any tips that you would give to employees in a situation where they feel disgruntled or unjustified or they feel wronged before initiating an actual full-blown claim against the employer? What would you suggest that they try to do?
I mean, I would say consult a lawyer because you don't want to let your emotions cloud your judgment. Right? You need to know what your rights are and what the company's rights are. Right? Don't inconvenience yourself by commencing an action where the outcome is not going to be what you want.
Yeah.
Right? Or you don't have any basis for commencing action. Right? Just seek legal advice. I mean, plenty of lawyers are willing to have a free phone call. Right? Just have a chat with them. Put your emotions aside
and listen to what the experts have to say, right?
Yes.
And it could at least give you the data to make a balanced, calm, informed decision.
Yes, and I mean, a lot of times if you come to the company and without any animosity, be reasonable with the company, a lot of times they're willing to give you a little bit extra, right? Versus if you go to the company and you say you've been mistreated, they go on a defensive, right? So keep things friendly with the company, right? Or at least consult lawyers first, know your rights, know the company's rights, and then you can decide how to move on from there.
Very last question then, now from the employer's perspective, when it comes to terminating employees, to avoid these kind of hiccups or misunderstandings, what would you remind them to do, employers?
First things first, pay the notice pay. If you don't want to pay the notice pay, make sure you have good reasons for doing so, right? So usually this will involve an investigation. It also depends on your employment contract, right? Is there a formal process where there has to be an inquiry into the actions, right? Then you have to look at your handbooks and all that, right? But if you are going to withhold someone's notice pay, you need to ensure that due process has been done, right? You need to give your employees a fair opportunity.
Otherwise, the safest way, even though you feel you have very good information, data, and evidence of a person performing under par or outright being, difficult and disruptive and dishonest, the safest way for yourself as an employer is to just give notice according to the terms of the employment agreement.
Just exercise your right to terminate the employee and say, thank you very much.
Even though you and I know what the reason are, on paper, I'm just going to say that it's just notice.
Yeah,
right?
Exactly.
Thank you very much again for explaining all of these very difficult and prickly topics. I really appreciate you making them sound a lot simpler than they actually are. Once again, where is the best place for people who haven't connected with you before to find you?
Well, you can drop me an email at ivan@pdlegal.com.sg.
Otherwise, LinkedIn, I hear, is always the best place to get in touch as well. Thanks again for joining us. I hope you've enjoyed and learned a bit more about the law today. If you like what you hear, like and subscribe for more legal things.